Yeah, man. It's been all right. Had a real significant dip back
All right,
time.
Spirit works through that now.
Good morning, everybody. Please have a seat. All right. Superior Court of Screven County, today is Friday, March 19, 2021, at 9 o'clock. We're here today on behalf, or in regard to, a motion, defendant Jacob Thompson's renewal of motion to prevent the state of Georgia from grand jury shopping. And Mr. Barber, and Mr. Ayers, this is your motion?
It is, Mr. Sam Dennis is also.
Good morning. Tell me your name.
Sam Dennis from Valdosta, Georgia. And I've been asked to present today's motion.
All right.
And we're ready to proceed.
Very good. All right, and Ms. Totten, Mr. Black, you were responding on behalf of the state?
Yes, Your Honor, I'm here on behalf of the state and respond to the motion.
Okay, all right. Mr. Dennis, if you want to go ahead and proceed, I'll listen to what you have to say.
Your Honor, if we could, we have one preliminary matter.
All right.
That Mr. Black is going to address before we get started on the motion.
All right, hang on, Mr. Dennis, let's see what the issue is. What is Ms. Black?
Your Honor, we served some subpoenas on defense counsel this week in an attempt to, on a subpoena to take for some information that we have requested, and we would like to address that before we begin our motion.
All right, we're good.
We served this subpoena, we'd like to have it answered.
All right.
And what we subpoenaed was all of the names and contact information of all contributors, direct or indirect, to the legal defense fund of the defendant. And so we would like to have those things before we begin, and we're ready to proceed on that issue as well.
All right, Mr. Dennis, are you planning to argue that, or Mr. Hube, I see you heading towards the front?
Judge, I have been subpoenaed, I don't know that I know anything about subpoenas, except I'm supposed to do.
All right, go ahead. Mr. Hube, you respond on behalf of the defendant?
Yes, Judge, I just have, a few minutes ago filed a motion to quash on behalf of Mr. Barber and Mr. Ayers, and I've just handed a copy of that, motion to Mr. Black.
And what is the nature, first, Mr. Black, tell me the nature of the subpoena, what's the purpose of that?
Certainly, Your Honor. Judge, subpoenas have been served specifically request documents, objects, and things of all writing, photographs, or other documented evidence, which contain the names and contact information of all individuals and entities which have made any form of monetary contribution to or on behalf of Julian Lewis and for family. But we also filed one at the same time to the attorneys for Mr. Barber and Mr. Ayers for Jacob Thompson, sending them both out to both of those parties. Particularly, what we're getting at here is, I'm going to get rid of this if somebody's not standing too close to me.
Thank you.
What we're getting here is that the crux of, and the title of this particular motion is that the district attorney's office is being accused of grand jury shopping. Any person who has contributed monetarily as an individual or as an entity to the legal defense fund would have had contact with, directly or indirectly, with the defense and the defense team and the defendant. Therefore, it means that if we are to seek a fair and impartial grand jury and a fair and impartial trial jury, then that information certainly is relevant to these particular cases. The defense, over the last couple of motions, have been breaking their back to try to force the DA's office to present this case to this specific grand jury. And I've now been served with a motion to quash to refuse to turn over those names. And it is our position that those two things are related. And so that's why we think it's relevant and proper. Now, I've had this motion quashed about 90 seconds, but I'm gonna see what it says.
Judge, I can get the board a copy of that.
Oh, yeah, I'd like to have that, please. Thank you.
We don't, first off, it is, certainly lists the issuing party's name, certainly it does, it was served properly. Furthermore, as to the attorney-client privilege argument in subsection C, we're not asking for information about what has been communicated between the defendant and his attorneys. What we want, that no attorney-client privilege exists as to private parties or individuals out in the county or out in the world who have sent money in to donate to his legal fund. There's no attorney-client privilege there. Certainly, it may not be in possession of it right to this second, but it can be. I get subpoenas about things I don't have in my hand right this minute, but are certainly accessible to. It is clearly relevant because the crux of this entire motion is to accuse the DA's office of shopping for grand jurors. And so therefore, we want to know who has donated to this legal monetary fund, because we feel that is in fact the defendant who is shopping for grand jurors. And the two are related. And so therefore, it is not unreasonable or oppressive. That should be an easy list to get. I'm sure there are bank records, I'm sure there are lists, I'm sure there are online records. And so that's why clearly these two things are related, because the motion is a push to make the DA's office present a case to a specific set of people. Basically what we want to know is, are those set of people been contacted with or influenced by the defendant by and through these particular issues? And that's why we follow the subpoena.
All right. And Mr. Hube, you're responding on behalf of the defendant?
Yes, Your Honor, I am.
Your Honor,
Yes, sir.
I know Mr. Hube is preparing to respond. We have also filed a motion to quash as well. We can present one to the court if the court wants that now.
Let me get this part done, and then I'm going to ask you to respond, Mr. Johnson. Thank you.
Does the court have a copy of the subpoena?
No, I might have them if you provide me. I got one.
All right,
Here, one.
no, okay.
Good. This is the one you're referring to, the one that you, that Mr. Barber and Mr. Ayers were served. Are you referring to?
This is the one I have been supplied,
Okay.
and I've shown it to Mr. Black, and he's indicated that that looks
Yeah,
like a copy of the one that.
Yeah, there are two subpoenas. Are
Yeah.
you referring to the one that Barber and Ayers got, or are you referring to Johnson and Lewis, or both?
Only Barber and Ayers.
Go ahead.
So, judges, we've put in the motion, there is no information with regards to who issued this subpoena, other than the clerk of court. In other words, it doesn't say district attorney's office, it doesn't say Barclay Black, Daphne Totten, or anybody else. I've issued a lot of subpoenas, and it's always had my name on it, so that somebody would know who's doing it and who to contact to say, you know, I don't have this, can we work it out, whatever needs to be done. Specifically with respect to Mr. Ayers, he was not personally served as is required by law. My understanding is that a copy was maybe left in his office. The code section that governs service of subpoenas is 24-13-24, and it requires personal service or registered or certified mail or statutory overnight delivery, and none of those things were done with regards to Mr. Ayers. I think Mr. Barber was personally served with this subpoena. It's our position, Judge, that this information is wholly irrelevant to the issues to be tried in this case. Clearly, the state's making the argument that the information they seek is relevant to the grand jury proceedings. I would disagree with that, but if we assume for a second that they're right, if we accept their position, it would seem to me that what they seek is only relevant to the grand jurors who are currently impaneled to serve on the grand jury in Screven County. And it would also seem to me that the appropriate way for the state to address the issue that they think is out there is to simply impanel that grand jury, call them back in and say, hey, have any of y'all given money to Jacob Thompson, his family, or his lawyers? They are in front of the people that they are concerned about at that time and can ask the specific questions that they're wondering about. I don't know why that's not how they're trying to gain the information that they seek. To the extent that there's been any communication between Mr. Thompson and his attorneys regarding anybody who's given money, then that would implicate the attorney-client privilege. Additionally, Judge, what they're asking for is information regarding anybody who's given money. So that potentially reaches a whole lot of other people outside of the current grand jurors, and certainly that would be inappropriate and unnecessary and not relevant in any way, shape, form, or fashion to what's going on in this case. And if the court will take a bigger picture view of this, to go back to law school and use some law school terminology, this is an awfully slippery slope. If the court's going to authorize the state to seek information about who's paying defendants' lawyers, I don't know that that's a can of worms that this court or any other is going to want to open up. I think that the court on its own can think about all of the issues that would be raised if you allow the state to do that. We've also put in our motion to quash that this information is not in the possession of Mr. Barber or Mr. Ayers, and that this subpoena is unreasonable and oppressive. According to 24-13-23, the court does have the ability to quash the subpoena if it finds that the subpoena is unreasonable and oppressive. Your Honor, once the motion to quash is filed, the burden shifts to the state to show that the documents sought are relevant. That's Harris versus the state. It's 341 Court of Appeals 831. It's a 2017 case. And I cited only for the purpose of citing that particular holding by that court. Factually, I don't think that it's terribly relevant, except for just that one small part. So again, Your Honor, there are a lot of problems with this, and I think that it's an easy fix if the state really is concerned about funding. Then they simply call the grand jury back in, and they ask those people, have you given money? And of course, if the court denies the motion that's before it today, not this motion to quash, but the other motion that you're here on, and the state never brings this grand jury back for a callback, then all of this is totally irrelevant. We think it's irrelevant anyway, but then these grand jurors are not going to hear this case. Obviously, if the court decides to grant the motion and to order the state to present the case, the state just shows up and asks the grand jurors, does anybody give money? I think that's the avenue to get where they want to go. But to force the attorneys to turn over this information is, again, I don't think something that this court wants to set as a precedent. And we've outlined in the motion what our issues are with it.
Thank you. Mr. Johnson, you're not a party to the matter, but you are being subpoenaed here today, so I'm gonna let you, give me some input. How about Ms. Lewis? Is anyone here on her behalf?
I represent Ms. Lewis.
All right, so you're appearing on your behalf and on behalf of Ms. Lewis. All right, go right ahead.
May it please the court, we filed this motion to quash the subpoena and alternatively for this court to enter a written order of protection as it relates to my person as well as to Ms. Lewis. Ms. Lewis, as the court knows, is a victim and in this matter and is a non-party. She is the widow of Julian Lewis. Julian Lewis is accused of being killed without justification by defendant Jacob Thompson. Your Honor, in our motion, we have given you the facts as we know it at this point. In this motion to reconsider, this subpoena seeks to compel my appearance here today, as well as Mrs. Lewis's appearance. We were served with this subpoena on Wednesday evening at 4:30, less than full 48 hours notice to produce what they have requested, if it even exists, and to appear.
And for the record, that would be Wednesday, March 17, 2021.
That's right.
All right, go ahead.
Your Honor, the subpoena, as the defense in this case has noted, is not directed from any particular person. But beyond that, on its face, it cites no authority to compel anything from a non-party and from an attorney of a non-party. Your Honor, this subpoena should be quashed. It is unreasonable and oppressive. The standard for unreasonable and oppressive subpoenas is articulated in United States versus Nixon. And in sum and substance, Your Honor, the state has to clear three burdens that it certainly cannot: relevance, admissibility, and specificity. Your Honor, this subpoena seeks production of information that is simply not relevant to this motion to consider under OCGA 24-4-41. The requested production is not relevant within the meaning of relevance. The names and contacts of all individuals and entities who may have made any form of monetary contribution on or behalf of Julian Lewis or his family does not logically tend to prove or disprove any material fact whatsoever that is at issue before this court in this motion to reconsider. We would draw the court's attention to Britt versus State, 282 Georgia, 746, 2007 case, where it was a death penalty case. The defense attempted to subpoena records from the executive director of the public defender standard counsel. They were concerned with funding of capital cases at the time. I think you may recall that defense counsel will contract attorneys with the Office of Capital Defender and feared that they may have inadequate funds to defend their client. They were seeking documents to show this, and the trial court declined to quash that subpoena. The courts held that that was error because the documents requested bore no relation to the guilt or innocence, and they held that it was entirely irrelevant to the criminal case. And although at that time Britt versus State was decided under the predecessor statute to the one that we have cited, 24-4-41, those statutes, the predecessor statute and the successor statute, are identical in that court may properly quash a subpoena that is unreasonable and oppressive. It is well established that once we file a motion, the state has the burden. If this is actually a subpoena from the state, it's not clear on the face of it that the documents shown are relevant. Obviously, items that are not relevant need not be produced. Secondly, the subpoena seeks production that is privileged information under 24-5-501A2. This, on its face, seeks communications between attorney and client in violation of the oldest privilege of confidential communication known to the common law. And as such, it should be quashed. The subpoena lacks specificity as required by OCGA 24-13-23B in that it requests a blanket all documents, writings, photographs, and other documentary material in your possession, custody, or control. In short, as my grandfather would say, cutting across the field, this appears to be a fishing expedition. The state has offered nothing to show that the things they have requested even exist. And it's hard to imagine a legitimate interest in the state of knowing who has supported the victim's family during this time period. And as the defense has noted, if they wanted to know that information, they can simply ask it in a grand jury summons questionnaire, or in a trial jury summons questionnaire, or in their court diary. And so the state cannot properly argue today that they need this production to prepare for trial, because the case has not even been indicted, which is further reason to quash. And the failure of this production today is not likely to unreasonably delay a trial, because the trial has not even been set. Your Honor, this subpoena was not served timely under OCGA 24-13-26, and that statute authorizes the court to consider under the circumstances and expressly prohibits subpoenas that are served with less than 24 hours notice, but it authorizes the court to inquire whether under the circumstances the subpoena was served within a reasonable time. Again, we will serve this on March the 17th, 2021 at 4:30 in the afternoon. It was served to me personally, was served by leaving a copy with the staff, and we think under the circumstances that is unreasonable. Your Honor, Betty Lewis is a victim as defined by the statutes of this state and the Constitution, particularly 17-17-1, as well as the Constitution of Georgia, Article 1, Section 1, Paragraph 30. The Georgia Crimes Bill of Rights provides that individuals who are victims of certain crimes have certain rights, and that is the right to reasonable, accurate, and timely notice of any scheduled proceedings. And Your Honor, victim Betty Lewis, who's in the court, was notified of this hearing on March 17th at 4:30 as well. The district attorney had notice of this hearing and failed to notify, as they are obligated to do under the crime bill, Ms. Lewis, and also failed to notify her counsel if they chose to do so. Your Honor, at the core of the crime bill is an effort, and it's expressly stated, to protect the dignity of the victims in cases. The state has filed a subpoena against Ms. Lewis and myself to satisfy political considerations, to appear to be fair to both sides in this matter. But there's only one side, and that is the fair administration of justice. We pray that you would quash this subpoena, that you would issue a protective order, keeping the district attorney from harassing, further encumbering Ms. Lewis with the burden of having to defend additional subpoenas and any other relief that you so desire.
All right. Mr. Black, any response?
Sir, first off, in the request of these documents, what we are talking about really is a question of thoroughness. If the shoe was on the other foot and we were dealing with some sort of defense subpoena, which certainly have occurred, then for me to simply say, well, you just ask no witness. That's fine, that's all fine and good. But any attorney worth his salt or her salt needs to take that extra step. Hoping for the answer you want or not answer you want is one thing. But having that transcript that you can go back to, or having those documents you can go back to as you work through those facts is important, as we all in this room know. This is a finite list. We're not asking for all and sundry across the world. There's a specific list of people who have or have not contributed to these legal defense funds. Particularly, the relevance here is that we're talking about jurors, and not just jurors in the current impaneled jury, grand jury. We're talking about jurors in the future who may be impaneled in later grand juries, and we're talking about jurors who may be impaneled to try this thing. That's the relevance, and that's why we're getting at this. But particularly, this list, these lists in particular, but the list from the defense, in this case, would show a contact between the defendant and potential members of the grand jury or jury or trial jury, one. And so that is potential tampering. And two, it shows a pecuniary interest between a juror, grand juror, and the outcome of this case. If a juror or a grand juror has donated money to and has created a pecuniary interest in the outcome of the case, then that should disqualify them. But that's the issue we're trying to get at. And so this is not just for this proceeding, but for all future proceedings until the end of this current matter before the court, between the conclusion of the state of Georgia versus Jacob Thompson. Finally, we believe that it is, of course, relevant to today's hearing because there is a correlation between this list, these lists that we're asking for, and the list that we've subpoenaed, and the information that the defendant so desperately wants to keep hidden, and the potential jurors for all proceedings now and in the future on this case. And that's why we want it. And that's why we think it's relevant, and that's why we think we should have it.
Real quick,
I guess if your motion's taken, I guess you have a right to respond.
we got the burden, Judge.
I'm sorry?
We have the burden.
I know, I understand.
Your Honor, I'm trying to find a specific site for you on this. You'll give me just a minute.
Oh, hang on a second. Mr. Johnson, you would happen to have an extra copy of your motion required. Clerk says she can make one if you don't have the problem. Thank you, sir. Appreciate it.
I'll get a site to you in the very near future, but I believe that in order to be qualified to be a grand juror, you gotta be a United States citizen, you gotta be at least 18 years old, you gotta be a citizen of the county, and if you were convicted of a felony, you have to have had your civil rights restored. I think that's the list. So whether or not somebody's given money to any other person, whether it's Jake Thompson or anybody in Mr. Lewis's family or anybody else, I think is totally irrelevant because that's not a disqualifier. And if that's the case, and if we're only looking at those factors that qualify somebody to be a grand juror, again, financial contribution does not appear on that list, and that would be something I think that would be improper to be looked into. Again, the state wants to look into it. They ask the grand jurors that are there, and that they're at their disposal essentially. The state's the one that gets to call them in or not on a callback, which is the situation that's the posture that this case is in now. So we can ask you to quash this subpoena.
All right, the court's going to grant both motions to quash in this matter. I will note for the record that the subpoenas do not provide who requested them, and there's a command in the last paragraph on both subpoenas, which is boilerplate, but it implies that the three judges of the circuit commanded it, which we did not. I believe the defendants' attorneys are both protected by attorney-client privilege law. I believe that Mr. Johnson likewise as attorney and as an attorney for Ms. Lewis is protected. Certainly believe Mrs. Lewis is protected. I believe these subpoenas are overly broad, unreasonable, oppressive. They're not narrowly tailored and designed to identify grand jury bias. Mr. Hube mentioned 4 factors for a grand juror to serve, but there's also a 5th factor, and that's addressed by the court in the instructions that the court gives and gave this grand jury, which is in any particular matter, if you are related within the prohibited degree, which is currently the 3rd degree, used to be the 6th, or have an interest in the case, either by knowledge of the facts or other connections with the case, you're to, each grand jurors involved are to accuse themselves or remove themselves. That's why we have 16 to 23 grand jurors in the room at the time, is to give enough room if somebody needs to step out, they can step out. And I do believe, frankly, I believe in the fidelity of Screven County grand jurors. I was raised here. I think if a grand juror in this county says, I don't have any connection to the parties, I don't have any kinship to the parties, I think unless there's some compelling reason to not believe that person, I think I would accept his statement to that effect. So I'm going to deny both, I'm going to grant both motions to quash, and we'll proceed with the defendant's renewal motion to prevent grand jury shot.